Any mention?
May I please, Your Lordship, I beg to mention item number 44. Item number 44.
44.
Yes.
Capital enterprise. Who's other side?
No objection, Your Lordship. No objection, Your Lordship.
No objection. Okay, this week we'll go easy since all have come holidays. From next week, we'll do some work. Yes.
Much obliged,
2
Lordship.
weeks. Yes.
Please, my lord. My lord, I beg to mention item number 38, my lord. I pray for 2 weeks' time. No objection, lordship.
No objection. Token Rava.
Yes, my lord.
2 weeks. Yes. Yes.
Much obliged.
I beg to mention item number 34, my lord.
34.
My lord. Come up next week, my lord.
34 is connected to 33.
Yes, my lord.
Where's Mr. Pathak paying the other one?
Yes, my lord. Mr. Pathak is appearing.
Does he know the seeing adjournment?
No, my lord. I have not
He doesn't
informed.
know.
My lord.
Who's there on his behalf? You inform him
My lord, I'll inform him.
in 2 weeks.
Next week, my lord.
Okay, 2 weeks. Yes.
Much
My lord,
obliged.
item number 39 as well, my lord.
39. 39 is. Why you want to take adjourn 39?
Mr. Paul is not here today, my lord.
My lord,
39?
my seniors are still on, like your lordship.
He's on legs. What do you mean?
My lord. Oh, he's speaking. My lord, he's before the division bench, lordship.
No, this 39.
Yes.
Doesn't matter if it's on legs or not, but petitioner, you're a petitioner.
My lord, I'm going to petition.
No objection, Lordship.
No, not the question, no objection. This matter has to be heard.
My lord, may fix it next week, my lord. On Monday.
Monday not possible. Monday you can't. Yes, after 1 week. Due to the absence of the argues in a counsel, we have the petitioner. Yes. Yes.
Bless, my lord.
May it please, Lordship, I beg to mention item number 41, Lordship. Lordship, I pray for some time in this matter.
Some?
So I am praying for 2 weeks' time.
No objections, my lord.
Yes, 2 weeks. Yes.
Much obliged.
My lord, a similar prayer for item number 46, my lord. On behalf of Mr. H. Karmanang.
You are well.
No, my lord. Can you have the matter after 2 weeks,
So 46.
lordship?
Follow.
Deeply obliged.
Supplementary list, item number 1.
Please, Your Lordship, I beg to mention item number 49, Your Lordship, of the hearing list, Your Lordship.
Who's the petitioner?
Your Lordship,
Special counsel is not keeping well.
he's
There's
not
no
well,
objection.
Your Lordship, that's why. Your Lordship, this matter can come up for 3 weeks, Your Lordship.
3 weeks. Okay, 3 weeks. Yes.
Much obliged, Your Lordship.
Some
Making
moments,
a joint mention for item number 42. This matter may kindly be taken up for 2 weeks, my lord.
2 weeks. Yes. 2 weeks.
Obliged, my lord.
Lordship, I beg to mention item 33, Lordship.
$33.
Yes, Lordship.
It's all been mentioned by after 2 weeks. Yes.
Obliged, Lordship.
Supplementary list, item number 1.
Yes.
Your Lordship will please to give a direction on 11/6/24 to expeditiously call for the interview of the petitioners. But even after the 5 months, my Lord, no step has been taken to call for interview. And still they are facing the same danger of being thrown out of the job.
Where's the direction?
Direction is at page. My lord, page 24. Start from
Yes.
page 24 to 25. The direction is the page 25, my lord, the operative part.
Okay. Yes, I heard Mr. Siddiqui issue notice. Interval 3 weeks. Steps to get this AD within 3 days. This also.
Item number 2.
So this is contempt application. The operative part of the judgment is at page 15, Lordship.
Page?
Page 15, para 16.
Where was the direction?
Para 16, Lordship.
Okay.
16:16. 3 months' time was given to the directed to the managing committee to conduct an inquiry, Lordship. There are two directions, Lordship. One is to conduct inquiry within 3 months' time, and the other direction is to pay the back wages. Now, till
When is
date,
the order passed?
this order dated. This is 13/5/24, Lordship.
Yes, sir. Let me say, Honorable Learned Counsel of Petitioner. Issue notice. Returnable in 3 weeks. Steps were taken within 3 days. Yes, this also.
Item number 3.
My lord, we are challenging the show cause notice issued by the inquiry officer.
Why?
My lord, what happened? The petitioner is an assistant teacher in the Maurang UP school. Petitioner is an assistant teacher in the Maurang UP school.
Maurang?
Maurang LP school, enjoying the sanction post. Now the managing committee has issued a show cause notice, claiming that he had absent from duty for 40 days. So he had given a reply. After giving reply now, managing committee has appointed the secretary of the managing committee to conduct the inquiry. And now the inquiry officer, who himself is a secretary of the managing committee, has issued show cause notice to me.
The same inquiry officer issued show cause notice to you only?
My lord. Therefore, my lord, just Lordship, can you see the...
Where is that?
My lord, the show cause notice, first show cause notice, page number 41, my lord.
Now, how do you say is a secretary only?
My lord, he is the secretary of the managing committee.
41.
My lord. 31. 41. 41, my lord.
41, yes, 41.
41.
So and so.
Yes, 40 days, and signed by secretary.
Secretary of the authority.
Yes. Now he, managing committee is a disciplinary authority. Then I've given my reply on page 43.
Yes.
And thereafter, my lord, page number 44, new show cause notice issued by inquiry officer. We have challenged this one. Lordship, kindly see, number 1, the undersigned proposes to hold an inquiry against you on the rules such and such and such. My lord. Now, you are directed to submit within 7 days of receipt of this communication written statement of your defense, and also to state whether you are desired to be heard in person. Number 3, my lord, that you are further informed that if you do not submit your written statement on or before the specified date in paragraph 2 above, or do not appear in person before the inquiry officer, or otherwise refuse to comply with the above directive, inquiry officer will hold an inquiry against you ex parte. Now, signed by the secretary himself.
He's the secretary managing committee.
He's the secretary of the managing committee. Now
he say that where is that?
My lord.
Where is that shown?
My lord. Lordship, kindly see page number 41, the first show cause notice.
41 years. Who's this person?
Now, I'll show my lord the inquiry officer.
No, where they
secretary, my lord.
Where they say that he's so and so the punishable inquiry officer.
My lord. Lordship, kindly turn to page number 17, my lord. The formation of the MC, my lord. Managing committee.
Yes.
Secretary, my lord, Joblin Wala. Now
Secretary is
yes.
John Walang, right?
Well, my lord, he is the one who issued show cause notice to me, my lord, 9 October.
Now, where has he been appointed as an inquiry
My
officer?
lord, may I kindly sit in the content of the show cause. Number 1, the undersigned proposes to hold an inquiry.
Where?
My lord, page number 44.
No, where do you show that he's been appointed?
My
The
lord.
other sign, yes.
My lord. So he assumed the role of the inquiry officer. And para 1 and para 3, can you see? He claimed himself as inquiry officer. Para 1, he said he undersigned proposes to hold an inquiry. Who is the undersigned? Secretary. Now, para 3 also, he said that the inquiry officer may hold an inquiry against.
The school's the grant in aid school.
Is the grant in his school. And my lord, he himself is the witness, page number, my lord, 51.
He's inquiry, he's the district authority, and the witness also.
He is the witness also. So I'll place one decision, page number 51, my lord.
Yes, anything to say?
I'm appearing for the state. Respondents 3 to 5.
Yes.
The managing committee and the
issue
inquiry
notice,
officer.
right?
Yes.
Well,
my lords.
In the meantime, lordship kindly stay the matter, impunity, not this.
Is a council with so and so? For
The
the
managing
petitioner.
committee also comprises of all the family members, apparently.
That's how it goes. Yes, all in the family. Yes, also issue notice. Ms. S. Shams present, Jilanji is present except on behalf of respondents 3, 4, and 5. Notice to issue to respondents 1 and 2 within 3 days. Stop. Next paragraph, Mr. Senior Counsel submitted that the writ petitioner has preferred the instant writ application against 2 show cause notices. 2 show cause notices.
2 show cause notices.
Whereby inquiry has been proposed to be held against him on charges of being absent.
Absent from duty.
Absenteeism from duty. Stop. His contention is, however, that the secretary of the managing committee himself, who issued the show cause, is the inquiry officer as well as one of the listed witnesses in the said proceedings. So he further submits that the entire proceeding being vitiated from the initial stage itself, some interim protection may be given to the petitioner. Next para, Ms. Sham submits that the government has no limited role to play in the matter, as it is the managing committee itself that's taken the action. Next paragraph, in consideration of the facts of the case, and consideration of these facts as placed by listening counsel on examination of the records, a prima facie case made out for interim orders at this stage. Accordingly, the show cause
Notice dated 9 October 2024.
shall remain suspended until the next date.
Deeply honored.
Yes, on so and so.
Item number 4.
This matter appeared last time. Yes, Mr. General, what is the problem with this matter? When an application had been put, it came to Registrar General asking for extension of time, we had given it. And now again,
Yes,
what does the MEC say that who's appearing in the case?
My lord, for the other side, Mr. Gautam is appearing. I believe one of his colleagues, junior colleagues, turns out that she is now related to the presiding officer in Nongpo, my lord.
So how does it affect the case?
Frankly, my lord, it doesn't. It doesn't.
It's stage of judgment, correct?
It's at the stage of judgment, my lord.
Then what do you propose to do?
My lord, if the presiding officer has expressed a reluctance to take up the matter in view of this peculiar circumstance, based on lordship's order, maybe she will be strengthened to take up the matter. Either that, my lord, or the matter can be remanded back to Shillong, my lord, the original court.
But original court can it take up the matter in Shillong? Who's the member MEC in Shillong now?
Madam Rimbai, my lord. Lordship, if I can draw. Yes, my lord. If I can draw Lordship's attention to order dated 2nd May, passed by this Honourable Court in the original transfer petition, 2nd May 2024.
Yes.
I'll just read the first para, my lord. Since Srimati so-and-so Judge MSCT has recused on the ground that she is related to Sri so-and-so, who was one of the counsels for the complainant, and that the parties have agreed that the matter may be taken up by the judge who is hearing MSCT case at Nagpur, both counsels submitted that the integrity of the officer who recused the matter is not questioned, and that they have no objection if the same judge takes up the matter. Since the presiding officer is recused, this court did not want to compel the judge to take up the matter. So, my lord, on the last occasion, on the very first occasion itself, both sides, my lord, had expressed our complete confidence in the Judge Shillong, Judge MSCT Shillong. But
No,
at that time, my lord,
this earlier order of Chief Justice says that
Yes,
since presiding officer is recused, this court doesn't want to compel the matter. So we can't compel the judge now to take up the matter. Then?
True, my lord. True, my lord. But this was then, my lord. Now, in view of the fact that the matter has again been recused by the present judge.
Where's Mr. Gautam? Where's Mr. Gautam? Yes.
May please, Your Lordship, I'm appearing on behalf of
Yes.
Mr. C.
You have any objection? The matter is taken up again by the same presiding officer in Shillong.
No, Your Lordship. No, Your Lordship.
No.
No, Your Lordship.
Okay, then we'll place it then before the original Judge MACT Shillong.
Very well, my lord.
Value
Take down. Yes. The incident matter has been referred to this court by the Honorable Chief Justice on the administrative side, which concerns a matter which had been transferred, an MSc matter which was transferred before the learned judge stroke member of MSCT Nagpur for disposal. However, it had for disposal, but however, on the same, having been taken up by the learned member MSc Nagpur, and extension also granted by this court by order dated
I apologize, my lord.
2024 for disposal of the matter. It has been, the learned member has expressed a disability to take up the matter in view of the fact that her daughter
Yes, yes.
Counsel with the is a counsel attached to the counsel is a counsel
claimant.
attached to a senior colleague who's appearing for the claimant. Next paragraph. Considering this peculiar situation, it is seen that by order dated 2/5/2024, passed by this court in TR, same number 2. TR T small r stop P stop bracket C number 2/2024. The matter, though the counsel have no objection to the learned member MCT taking of the matter, had been transferred to the court of the Judge MACT, as the Judge MACT at that point of time, as the MACT at that point of time stopped. Today, Ms. S. Jindal and Ms. E. Rani, appearing for the claimant and for the petition for the respondents, have expressed their consent and have submitted that the integrity of the officer who recused the matter initially from Shillong on the question and have no objection if the CM judge takes over the matter. Like, considering the facts of the case as it pertain on today, and as a matter is of which year?
2009, my lord.
Of 2009 vintage. In the interest of justice, directed that the records of the, what is it, the case number?
MSC case number 3 of 2024 in Nongpo.
24, from renumbered in Nongpo, be placed before the learned member MSD Shillong for disposal.
I oblige, Your Lordship.
Matter stands as good.
Daily use item number 1.
Yes. Yes, Baba.
Yeah, may it please Your Lordship. Your Lordship, this matter is regarding actually 2 medical certificates which has not been admitted as documents till date. Your Lordship,
Concerned 2 medical certificates, you agree which order?
both
you come here in the CRP against which order?
Both, Your Lordship, because there's an impugned order by the judge in MAC number 7 of 2017, and I had told the petitioner that we would have to go for appeal against that judgment. However, it was during the time of COVID, and she told me that she has somebody who practices regularly in the High Court. But however, no steps were taken till September of last year. Then she gave me the instructions to do the needful. Then, however, I was not of good health at that point of time, and I couldn't file the instant revision. And the suit was then endorsed from Kongphira as she was elevated to the court of Gatpho, A.E. Gatpho, Shri A.E. Gatpho. Then, White Order dated 26/7/2024, the suit was dismissed for default.
For default?
Yes, Your Lord. But on that particular day, I was at District Council itself. I was taking up a cross-examination in the court of Shrimati I. Pawa, another presiding officer. But by the time I had come back to the court of...
Order of dismissal?
Of
the dismissal?
Gatpho, Your Honor.
Yes. Now you see the first order you agree with is 13 September 2019.
Yes, Your Lordship.
There where they didn't allow the medical certificates.
No, Your Lordship. Actually, there's no specific order regarding the medical certificates.
This is page 65.
Yes, Your Lordship.
This is the appeal filed by you.
Yes, Your Lordship. I had stressed in the memorandum of appeal also regarding the medical certificates, and especially in the written argument that the other documents that were filed later on is of no consequence. The main documents that we want to be allowed is the 2 medical certificates. But there's no there's nothing said about the medical certificates.
See, the order is not against you, just come with page 93. Page 93.
Lordship, this is.
This is the one you're supposed to come against.
This is another appeal because against that particular order, before we could file an appeal, the defendants filed an appeal.
You are the out here. You are the appellant in this case, right? Below in this.
Yes, Your Lordship. That judgment ends. That judgment ends in page 77, Your Lordship.
No, 77.
Yes.
Okay. What is another one?
Yes, they file an appeal.
Okay. Sorry. Since there's so many orders, I got the wrong one. It ends in 77.
Yes, Your Lordship.
How does it end? Over the opinion, the opinion. Yes. So now these appeals had gone. They had filed an appeal also against what order?
Same order, Your Lordship.
Same order. Their appeal also was dismissed. Your appeal was dismissed.
Yes.
So you said no need to file additional documents. You already given the evidence. So let the suit proceed. Correct?
Yes, Your
So the suit proceeded and it was dismissed for default.
Yes, Your Lordship.
So now you agree. You can't maintain one civil revision against
I understand.
multiple orders.
I understand.
Now have you come against the dismissal default only? But
Actually,
if you don't challenge the civil default, it makes no meaning to challenge the other orders when the main case is already dead. Right?
Yes, Your Lordship.
So where's the order dismissing the suit for default? Where?
Page 97, Your Lordship.
Okay. Plaintiff after no step, defendants present, and counsel pays should be dismissed for plaintiff. Numerous opportunities have to take steps. Will appear for this court.
Lordship, prior to that, if Your Lordship.
Been called?
No, Your Lordship.
Let's see, Lordship. Yes, anything to say?
Your Lordship, the
See, we only concerned if the court's limiting its examination only to, he's come against the dismissal of the suit for default. That's all. But the presiding officer, why didn't you go for appeal before the judge against this order?
Lordship, because the judgment passed by the judge in MCA 7 of 2017 was to be challenged, and we had.
No. Why? Then why have you see, Mr. Thaba, you mixed up? It's the certain, what reliefs you are claiming. Now regarding appeals, those you can keep them under the carpet because why? Because there were there were miscellaneous appeals filed in connection with your adducing evidence, additional documents, which is in the way of a suit that proceeds. Fine, if allows or disallows, then the suit proceeds. But what has happened in your case is that those things were going on. Yes. You didn't file appeal those orders. These orders were past 19 or whatever.
Yes.
Then the suit proceeded and got dismissed.
Yes.
So now your only grievance which you should have is against the dismissal of your suit for default. And so for that, now this order has been passed by the court of the Sovereign Council Court, correct?
Yes.
So you have a ladder of appeal before the judge.
Yes.
So why have you come here directly?
Lordship, because the way the order was passed, or if your Lordship sees page 95.
Yes.
On 19th July 2024. Your Lordship, this suit was fixed 4 times in the month of July 2004.
So that
24.
is back.
No, Your Lordship, what I'm saying is...
see, on 19 July 24, plaintiffs after steps, defendants present,
yes.
praised to dismiss suit to default. For the interest of justice, last opportunity is given to plaintiff to take steps, feeling which necessary order will be passed.
Yes.
So fixed 26. And 26 also, whatever reason, you could not be there. And so it's dismissed.
Now, Your Lordship, on 19th, because the matter was.
We just condensed the whole, your whole case into that thing. Now, why have you come directly here when you had a ladder of appeal before the judge?
Now, Lordship, one thing is in the way the order has been passed. Your Lordship, I had no knowledge about that the case was fixed on 19th because, as per the CIS, it was not reflected at all. Because on 12th, it was fixed initially. Before that, it was fixed on 12th 7. On that day, there was a training for judicial officers regarding the new laws, the 3 new laws, and he had gone for the training.
You can make the same prayer for the judge. Why do you think you won't consider your submissions there?
Lordship, one more thing is, I had no knowledge about this date 19th.
You understand the
yes,
hardships that you face, right?
Yes.
But
then
why do you anticipate that you will not get a fair hearing before the judge?
Lordship, that is because I have come here because there is also that matter regarding the 2 medical certificates.
That's over. If your suit is not restored, you can't agitate that matter. If your suit is restored, then you can maybe agitate that matter.
Yes, I understand.
Now, as on today, where we stand,
I cannot.
You cannot.
I cannot.
That's all.
But
so you take a
Your
call.
Lordship,
I'll listen again for 2 days. You take a call. You can withdraw it. We send the file back down to the judge who will take up the matter.
One more thing, Your Lordship, I'll just want to bring to Your Lordship's notice that on 26/7, I was present.
Doesn't matter. We're not going to the facts at all.
I'm not saying about the facts, Your Lordship. I'm saying about the way the district court is functioning at present.
That is before the court of subordinate counsel court. I'm talking about why can't your appeal be placed before the judge? You'll ask them to place for the judge and to pass necessary orders.
Lordship,
on this petition.
Lordship, I'll just come to one short point, Your Lordship. Your Lordship, the presiding officer against whose order I have come, he sits at 12:30 onwards. And when I finish my cross-examination at 1:10 and I go down, nobody is there in the courtroom. And I see that my case has been dismissed for default.
That is not true.
Your Lordship, I was there personally. And
these allegations you made.
And Your Lordship, there is a direction from the judge that all presiding officers should sit by 11.
You make this complaint before the judge, because that is, it's the logical ladder of appeal. That's all. It's given a statutory appeal. See, this court can't usurp jurisdiction of the judge and say, okay, fine, we will restore the suit. So
Lordship,
you go there. I'll give you 2 days time. You come back on Tuesday. You just take instructions. Okay.
Because
otherwise, on all probability, we'll send the records back to the. This petition itself, we say, okay, fine, transmit it to the judge. He'll renumber it as a appeal against the order dated so and so, and they take on past necessary orders.
Okay, Lordship. But then I'll have to come back to this court only for the.
If you have to come back, you have to come back. But that is a normal procedural way. So you want me to remand it back?
If Your Lordship pleases, there's no problem, Lordship.
Yes, if this revision application has been filed as sealing orders dated 19/7/2024 and 26/7/2024, whereby the suit of the petitioner has been dismissed for default. Now, Mr. D. Thaba has submitted that he is constrained to approach this court with this application, inasmuch as he wants to bring to notice of this court the manner in which the subordinate district council court has conducted the case.
Yes, sir.
So, it is submitted that on 19th July 2024, when an order was passed that last opportunity be given to the plaintiff, the learned counsel was not aware about the date. inasmuch as per CIS.
It was reflected only in the evening.
It was reflected only in the evening as a fixation at the next date. Stop. He further submits that on 26/7/2024, when the matter was taken up, he was busy in another court in a cross-examination, and by the time you had filed Hazira.
I had, Your Lordship, but it's not reflected anywhere.
And we had filed Hazira and went to the court at 1:10 p.m. He found that the suit had been dismissed. Stop. As such, he prays for appropriate orders for restoration of the suit. I took act. Mr. Shampliang? Yes, Shampliang, no? No.
Yes,
Shampliang.
yes, Your Lordship.
Yes, stop. Next part, Mr. Shampliang, appearing for the respondent, however, has disputed the arguments made by the learned counsel for the petitioner. Stop. Next paragraph. This court has examined the matter, and it is noted that whatever be the reason or grievances that the petitioner might harbor with regard to the conduct of business by the subordinates counsel court. Stop. As the order is appealable under Rule 28 of the
Administration of
Khasi,
Justice.
The Khasi Hills Autonomous District Absolute Justice Rules 953. The judge, District Council Court, will be the appropriate forum to take up the instant matter for consideration in the form of appeal against the impugn orders. Stop. Accordingly, it is directed that the matter shall be remanded to the court of the Judges Council Court, which shall remember the same as an appeal, and take up the same for consideration and pass necessary orders thereon. Matter stands disposed of.
I did.
You've noted your grievance as well? Yes.
Item
Yes,
number 2. Item number 2.
Mr. Pasque, but who has to?
They're supposed to.
Yes, where's Dr. Mojka?
Your Lordship, he's on next, Your Lordship. Your Lordship, I think this matter will be taken up again.
Another vote, yes.
My lord, in this matter, state was supposed to supply them as per the last order, if my lords may kindly see. The center is not in a position to send the money, my lord, because the state is not cooperating. So whether the state has received any instruction, my lord?
We're not cooperating.
Lordship, in fact, Lordship, I have sought instruction from the department. I'm awaiting the instruction, Your Lordship. What I would pray, Your Lordship.
Just last order, Mr.
Lordship, I have seen it.
That office warrant dated 39.
Lordship, I have seen it.
Has also been produced showing the matter has not been taken forward due to not receive requisite information.
Lordship, yes, I've seen it. I've seen it, Your Lordship. Accordingly, we have sought instruction, Your Lordship, and we are yet to receive the instruction, Your Lordship.
The Government of India has taken up very seriously.
If Lordship kindly accommodate,
if
Lordship kindly accommodate us, Your Lordship, for some time, Your Lordship.
You've got a copy of memorandum.
Yes, yes, Lordship. Yeah.
Yes, Mr. Andy Shulai submits that though instructions have been sought with the pursuant to the order of this court dated 4/10/2024,
Lordship, yes,
are yet to be received. He prays funds allowed for the 2 weeks.
Lordship,
Obtain
Deeply
the
obliged, Your Lord.
Yes.
Lordship.
Surprise the court, yes.
Yes.
This accordingly and so on.
Item 2 to 12, Your Lordship, then 35, 36, 37.
Item 30.
Your Lordship, my appearance may be recorded, Your Lordship.
Where? Which item?
13.
Your Lordship, we have already taken step on behalf of the respondent.
Yes,
Yeah,
I have
hearing.
received copies.
Very
I'll
good.
probably be over by today.
Mr. K. Kashi, affidavit appearance in behalf of the respondent's number.
Respondent number 1, Your Lordship.
1, 2, 1 and 2.
1, Your Lordship.
1.
Yes.
You're from Matisha Kharla.
My lord.
Number 1. As such, service complete on respondents. He prays for allowed how much time?
2 weeks time, my lord, I'll file the shukos.
Section to the review application.
Highly obliged.
Highly obliged.
14.
May it please Your Lordship. Lordship, in this matter, we have already taken steps, Your Lordship.
One, how many respondents are there? 4 respondents.
Yes, Your Lordship. Lordship, on the next date, Lordship will file affidavit of service, Your Lordship.
Officer indicates that the service on full respondent complete just up to 2 weeks.
Your Lordship, there's an interim, Your Lordship, that may be
Yes,
extended.
Just up to 2 weeks for service report. Interim order shall continue next day.
Much obliged, Lordship.
15.
Your Lordship, I require some more time to file my rejoinder, Your Lordship.
How many times have you taken?
Just one time, Your Lordship. Today will be the
One
second.
time?
One time, Your Lordship.
Yes, as prayed for the 2 weeks time granted for rejoinder affidavit petition. Yes, answer.
16.
Lordship, in this matter, the petitioner is yet to file the affidavit.
Please, Your Lordship. Lordship, I'm praying for 2 more weeks' time, Your Lordship.
2 more weeks time
Yes,
for
Your
rejoinder.
Your Lordship, we have genuine reason for that, Your Lordship. If may be allowed to submit.
And
I have genuine reason for that, Your Lordship. The petitioner.
You mean you will give false reasons?
No, Your Lordship. Your
You
Lordship,
don't think that all lawyers give genuine reason? Yes.
Your Lordship, the petitioner are from Shalang, Your Lordship. We have a little Shalang, yes, Your Lordship. A little bit difficult in conversation with them, conversating with them, Your Lordship.
Different language.
No, Your Lordship. They are usually they are vendors. And
What's the difficulty?
we have a little bit
Whereas the
difficulty.
lawyers handle cases from people who stay behind Tora Peak also. There was no mobile that time.
I understand, Your Lordship, but then
Yes, 2 weeks for the time was prayed. Allowed for affidavit court rejoinder. This is the price.
I know it.
25.
Yes, Mr. Nomri, why you requested for today here for this thing?
My Lord, because your Lordship said pleadings are complete, but your Lordships wanted to dispose of this matter in the orders column. My Lord, the issue here is non-supply of documents.
No, but Mr. Chulai said that everything's been supplied.
Lordship, yes, that we have stated in the affidavit.
In fact, the affidavit says otherwise. The affidavit, they say that some documents cannot be supplied because of pending investigation. Number 2, because, my Lord, the matter is before the trial court in the criminal trial, my Lord. So, my Lord, now what has happened is, my Lord, out of 43 witnesses, 40 have been examined and the remaining 3 will be examined tomorrow. Now, I am prejudiced because I am not able to cross-examine them properly, my Lord. And tomorrow, my Lord, if any penalty is, my Lord, imposed, my Lord, the proceedings will be vitiated, my Lord. And judgments to that effect are there, my Lord.
43 witnesses?
Yes, my Lord. So out of
which document do you not have in your possession which you need for examination?
My Lord, there's a list, my Lord, which we have.
Where is that? In the rejoinder?
My Lord, my rejoinder, page 19, annexure 3. At serial number 4, which is at page 20.
Yes.
In In the second column, my lord, they say the documents pertaining to CID, PS so-and-so, investigated by so-and-so, the case is still under investigation. So they are not providing on this ground, my lord. Also at serial number 6, my lord.
So, why do you need this files? CIDPS case number 1.
Because, my lord, the charges in the criminal cases, my lord, are exact same as the article of charges in this DP, my lord. So, to defend myself, my lord, I require these documents.
Yes, Shulai.
Lordship, in fact, the submission made, Your Lordship, that this document, Your Lordship, because it is the admitted fact, Your Lordship, that the proceeding is going on. Those people can be called as a defense witness.
Without the documents, my lord.
Lordship, yes,
Without
along
the
with the documents.
These witnesses are the, my lord,
at the time,
These are which witnesses? Who are the 3 witnesses left?
Lordship, I'm not.
He should be knowing.
I'm not aware, Lordship.
The list of witnesses supplied to me is at page 50 of my petition, my lord.
Otherwise, you see, it works to your advantage. You don't give documents, then.
Yes, my lord. I do understand that, my lord.
If the submission is correct, Your Lordship, then that everything will be beschitten and will be to his advantage, Your Lordship.
That's what Court is saying. Sam Rana, Banshan Lingdo, and Ashish Kumar Singh left.
I think so, Your Lordship.
Or it can't be in that order. Maybe it's different.
They can't be summoned, Your Lordship. The investigation is done by the additional SP. He can't be summoned as a defense witness on behalf of the writ petitioner, Your Lordship.
Yes.
He can't be summoned, Your Lordship.
Lord, in my rejoinder, I have also enclosed the order sheets of the Lord, DP. If Your Lordships have page 23 of my rejoinder. Now, if Your Lordships comes to the order at page 25, this is dated 19th of August. Last paragraph, my lord.
25.
Page 25, this is 19th August.
Yeah.
Last paragraph, my lord. Second last paragraph, all 9 witnesses have been examined, were present. Witnesses called for examination were present. The charge officer, CO, made a verbal submission. The witnesses may again be examined in a matter pointing to the charges for which he is yet to receive documents. So till August also, my lord, these documents I have not received.
He said they can't, they seize, one is in the two separate CID cases.
Lordship, yes.
Yes, my lord, but it's exact charges, my lord. I have to defend myself, my lord. Under Article 311, I have a right, my lord.
How many witnesses do you have from your side?
My side, that I have not pointed out here, my lord. My lord, the matter can be closed with a direction that they should supply the remaining documents.
See, whatever documents they can supply, they've supplied. Now he's raised his hand, said we can't. Once that the ones pertaining to the CID case so-and-so investigated by the additional SP, and the others is seized by in another CID case.
Lordship, yes.
Entire proceedings is vitiated, my lord. Entire proceedings is vitiated, my lord.
These are
Lordship,
crucial.
can he come to 6, Your Lordship? Can he come to 6?
Yes.
At page 20, Your Lordship.
So I mean that the thing is that now, why can't you give them copies? Even if there's true copies from the court, you can get them.
Lordship, see, as per the IO, copies have been provided to under 207.
It's my right to get it from them, my lord. I don't have to go and apply.
See, Mr. Shulai, you tell your people you obtain 2 copies and give it to
Lordship, in fact, relating
these
to
are only 2 objections he has. That means why you want to jeopardize the inquiry proceedings? If 40 witnesses have been examined, it's a matter that's been very high profile.
Yes.
Then,
but
elaborate after 1 week doesn't matter. If you can postpone these witnesses. Yes, that is a matter of after 1 week to enable the learned AG to obtain instructions.
Lordship.
It appears that the matter concerning the supply of documents is still to be settled. You ask this problem. I will not record that, but then you can.
Lordship, yes. Lordship, yes. Lordship, yes.
26.
Apply, Your Lordship.
Lordship, my lord, I have received the Paravis comment in this matter. And it
His Lordship, I have got the instruction, Lordship, that I have not resigned, but I have taken a voluntary retirement. That I have, even in my statement also, I have made it, and I have called the petitioner also, that she said she did not resign, but she has taken the voluntary retirement.
Now,
so she some entertainment.
The letter that I have received.
Did you resign?
She has resigned.
Not resigned.
She has resigned.
She said she has not resigned.
This is the letter that she has written to us, my lord, that she has resigned. I have just received, my lord. I will print out and I will file an affidavit on that.
Where's Mr. Deb?
Mr. Deb is not well, my lord. She has resigned, my lord. As per the document, she has resigned.
What instructions do you have?
But she said
on 5th September 2022, my lord,
she did not resign. But she said that she filed an application only for taking the voluntary retirement. That was the instruction. Let them file it then.
No, let's see. Where have you said that?
No, in my petition actually I have mentioned. I have never stated that I have resigned. Your Lordship may kindly check the
petition. Only one lecture.
Yes, my lord.
Because this is the only letter that is provided by this one. Para 2 and Para 3 also I have
produce the record, my lord.
Ms. SD, please have some time to bring on record certain documents showing that the petitioner had not taken VRS as alleged, but in fact had resigned. This is the matter after
2 weeks will do.
It's expected next year he will be on board.
Much blessed, Lordship.
27.
May it please your Lordship. Lordship, on the last occasion, a last opportunity was given to us to file a rejoinder. We've sent it for signatures because
last opportunity was given.
Lordship will file it positively by Friday,
It's a
Lordship.
matter for hearing on so and so. You not see anything, you can find it. Though last opportunity had been granted to the petitioner, due to reasons shown, the General Affairs should be on board on the date of hearing. Yes.
Highly obliged, Lordship.
28.
You file affidavit.
Lord, yeah, I think this matter can be disposed of.
Yes.
Data has been already forwarded to the AG department for the releasing of pension.
Can we dispose of, my lord? I have received the leave salary, Lordship. The pension, leave salary, Lordship. So far as the leave salary is concerned, they have released. Now that.
Where's the communication? You see a moment to raise a communication dated 12 September 2024 indicating the fact that pension papers along with enclosures have been forwarded to the Accountant General. Respondent number?
7.
My lord, 6, Lordship.
Respondent number?
6.
6. Further, it is also seen that an office order of the same date sanction has been accorded to the payment of sum of a certain sum in the cash equivalent of these salary for 300 days. As the matter has been is under active consideration as proceeded, nothing remains for consideration. Instant writ application and same is closed. It is expected that the entire process be completed expeditiously. Yes.
My, at least
no time frame.
Time frame, Lordship.
It will be
Then
done now.
I have made a prayer for interest that issue may be kept in offend, Lordship.
Both it off.
29.
No, I have made a prayer for interest, Lordship.
You
That
want
issue.
matter be kept alive?
No, Lordship, no. That
Yes, however, Mr. S.A. Sheikh submits that before the disposal, however, Mr. S.A. Sheikh submits that though the matter can be disposed of, the element of interest not be kept alive, to be agitated at an opportune moment.
Yes,
at an opportune time. Understand this both of the process is
Hello.
Yes. Cipher.
29.
Yes.
Your Lordship, I pray for some more 2 weeks' time, Your Lordship, to file our affidavit.
Yes. For a 2 weeks' time, it's played aloud.
30.
May it please Your Lordship.
One second. Which one? What? 43, 45. Yes.
May it please Your Lordship. Lordship, we've just received the rejoinder yesterday, Lordship. So I humbly pray that if the matter could come up next Thursday for hearing, Lordship.
She's still in the college?
Yes, yes, she is.
There's urgency, Lordship.
Urgency because Lord, I'm the candidate who's been given the seat. I've taken
Accommodate her somewhere else before the career is jeopardized.
My Lord.
Doesn't matter, it's due to the lapses on their part.
So kindly, my Lord, next Thursday.
Yes, exactly. That's why I'm saying give a seat for you. You got a dental seat?
Yes,
upgraded to a MBBS seat.
It's for post-graduation,
This is a PG.
Lordship. Lordship.
In dentistry. Okay.
Kindly, my Lord, next Thursday, if possible. Next Thursday on the 24th.
As per Your Lordship's convenience.
Yes. Will you be travelling?
25th, Lordship.
20th was a Friday?
Lordship.
Friday.
Right, okay, fine. Council's pray that the matter will sit on 25th and an attempt to dispose of this matter next day.
Lordship, the interim order may kindly be extended till
Interim
such time.
order shall continue until further orders. Yes.
Lordship. Highly
Much
obliged.
obliged, Lordship.
31.
My Lord, as per Your Lordship last order, I am appearing for the bank, my Lord, respond number 5.
Yes, Mr.
And as desired by Your Lordship, my Lord, the bank has filed an affidavit.
Lordship, we received the affidavit in opposition today. We'll require some time to examine. Lordship.
But how do these things happen, Mr. Burari?
My Lord, one thing.
Oh, council, using this AI, whatever's happened, they are fooled.
Very rightly, my Lord, it is a fact, and we don't dispute and we don't deny that cyber internet transactions are committed almost every day in thousands all over the country.
Your bank must be facing a lot of issues.
There, Your Lordship's first order, Lordship was very right that it has assumed the magnitude of a scam or a plague. That is the word Your Lordship used. This is a case, my Lord, where the admitted fact is that the petitioner, on receiving a fictitious call from an unknown number, believed that.
Yes.
And thereby she was, my Lord, deceived. She fell victim to a fraudulent caller, a fraudster. No doubt that fraudster and fraudulent caller should be brought to book.
Yes.
We don't deny that. But the FIR is lost. At best, it is a case against, my Lord, the fraudulent caller. Bank, suppose I am a bank. She receives a calls. Our duty only is to see whether the right password has been given or not. We are not bothered about who called whom.
Exactly, but yes.
So she fell victim. I feel pity for her. But what is the role of the bank? The question here is the bank anyway, has the bank anyway collided with that fraudulent caller? That is number one for Your Lordship. And whether the bank, while allowing the transaction and subsequently by subsequent actions, went beyond the, my Lord, banking norms and the RBI circulars. That precisely will be my case.
See, one thing with the board is that the grievance is that, fine, that fraudulent transaction was done, money was, debited from account, but the bank had made a shadow, whatever the recovered amount, and put it back in account.
Yes,
so
but that
quite happy saying that, fine, the bank's taken action, my money is back, but again, suddenly the money went off.
So there lies the question. My Lord, in the petitioner, the petitioner has used the wrong word, retrieved to her account. It is not retrieval to her account, my Lord. What is in the banking parlance, it is called, I will show this RBI guideline, shadow reversal, that is temporary credit. When the petitioner does not become, my Lord, the absolute owner of the credited amount to her, it is conditionally given to her that, all right, we are the bank, we are holding an in-house investigation, pending that we are giving you, it is, I will show the terminology, this is called shadow reversal. My Lord, page affidavit in
You also should get educated in these things. Otherwise, we're sitting in jurisdictions now, So different type of cases are coming.
Yes, yes. Many cases, many cases. Paragraph 9, my lord, of the RBS guidelines, page 29. Affidavit in opposition. Lordship may have it. Paragraph 9 at page 29. This is the RBI guidelines. My lord, we are bound by this.
Yes.
Page 29.
Right.
Reversal time limit.
On being notified.
Yes. On being notified by the customer, the bank shall credit shadow reversal the amount involved in the unauthorized electronic transaction to the customer's account within 10 working days from the date. In fact, my lord, to the bank, it is not unauthorized transaction. We take it as an authorized. Because
Bona fide.
Bona fide, because we know that she, by using her own mobile, use her own passwords. Then, my lord, again coming, without waiting for settlement of insurance, the credit shall be value dated to be as of the date of the unauthorized. Here again, the word is unauthorized. Bank may also be at their discretion to decide or waive off any customer liability in case unauthorized electronic banking transaction, even in cases of customers' negligence. So, to us, it is not unauthorized. We are not bothered about what telephone conversation took place, my lord, between my customer and someone else. We are bothered about whether the right, from the right account, the right password has been, buttons have been pressed. Then, my lord, amount automatically goes to the beneficiary's account, my lord. This is, my lord, automatically digital, my lord. We cannot stop it. But the moment, after realizing that she fell victim, she immediately informed the bank, and bank immediately, my lord, by that time the money went away. Bank immediately stopped the, my lord, further transaction on our account. So, absolute bona fide we acted. And paragraph 7 also, lordship may have a look.
Lordship will examine.
One thing they have just received the
That's right, my lord.
That's right. Disadvantage.
That's right. They should get.
But this is a very, these things, I think the bank should layer another, a layer of security.
Police case has been cheating. Under the BNS, cheating has been registered. Let police come, we will place all the records.
Yes, affidavit has been filed on behalf of the respondent.
My lord, my presence may be heard.
Yes, yes.
S.C. Barbara, assisted by M. Smith.
Yes, S.C. Barbara, Leonard Senior Counsel, with so-and-so is present on behalf of respondent number 5. Stop. It's noted also that affidavit has been filed on behalf of the respondent and the same is taken on board. Stop. Ms. D. Cruz, Leonard Counsel petitioner of appraise has failed out.
2 weeks time,
2
Lordship.
weeks time.
My lord, the date may be fixed so that I can adjust. Can it be on 4th of November?
Yes, 4th of November, please be allowed to examine the CM to file the joint if necessary. This is a matter for.
In the meantime, my lord, the state also would like to file
yes,
report regarding the
yes,
criminal case.
Yes,
fine. Yes, the NSYNC on behalf of the state respondents also please be allowed to submit to file a status report with this court with regard to the police case. Accordingly, this is matter on 4th November for further orders. November 4th, my lord. Obliged, Your Worship.
I have instructions to appear for respondent 2. Private respondent.
I'm appearing on behalf of respondent number 1.
William?
Yes, sir. Sir, I require some time to seek proper instruction. I've just received the brief this morning.
Yes, Mr. R. Royston has another appearance today on behalf of the respondent number 1. And Mr. Emmett will appear on behalf of the respondent number 2. So they both pray for an allowed 2 weeks' time to obtain instructions and to file affidavit. Yes. This is after 2 weeks.
No, interim orders to continue.
Continue to the next date.
Interim orders to continue. Interim order.
Interim orders to the next date. Yes.
Deeply obliged.
Hearing, item 40.
Yes. What's the matter about Mr.
Your Lordship, here, Your Lordship, I have got a very limited prayer, Your Lordship. My prayer is only to dispose of my representation slip. Your Lordship, here, what had happened, Your Lordship, that petitioner here, Your Lordship, are the owner of the plot of land, Your Lordship.
Of the?
Of the plot of land, Your Lordship. And
Plot of land?
Yes.
Okay.
Then in the year 2001, Your Lordship, the respondent number 3 instituted a suit against me in the court of at Empathy.
In a court of?
Empathy court, Your Lordship.
Empathy court.
Yes. Then in 2017, Your Lordship, she submitted an affidavit, Your Lordship, claiming that she is the owner of the plot of land. And also she further claimed that she had her husband had purchased the said plot of land, Your Lordship, which is in Kacha Hanwood and sealed deed, Your Lordship. Kacha sealed deed. So which exposed her to action under Section 8, Your Lordship, because there is a transfer of non-tribal to another non-tribal, Your Lordship, which is in violation of Section 3 of the Meghalaya of Land Transfer Regulation.
Where's the representation?
Yes.
Page 25. Where is it?
My application, Your Lordship, is in Annex 3.
Annexure 3. Okay.
Yes, page 21, Your Lordship.
What happened to this application? It's been taken up.
No, Your Lordship, no action has been, no step was even taken, Your Lordship.
Yes, Mr. Harmi, you got instructions.
Lordship, here in this case, Lordship, the original of the plot of land is the grandfather of the petitioner.
No, I'm not bothered about that. What did the DC do with regard to this application under Section 8?
Nothing, Your Lordship.
Was it taken up ever? Dismiss or?
Lordship, I think it's still pending.
Yes, Mr. Paske.
Pending.
Your Lordship, I am appearing for respondent number 3 here. Actually, here the title suit has been decreed in my favor. Thereafter, the petitioners hearing the appeal through a civil appeal, which was dismissed. The second appeal was filed and which is pending adjudication at the moment.
Where's the second appeal? Before this court?
Before the court of additional to Deputy Commissioner Ampati, Southwest Garo Hills. They have not brought all those things on record. The title suit is at page 34 of my affidavit in opposition.
Who was the petitioner here?
Your Lordship has it? My affidavit in opposition?
Yes.
Page 34. Your Lordship, a title suit was filed by me. Prior to that, a title suit was filed by me in the year 2001. And in that part also, I have received the right through the father of the petitioner number 1 herein. And Your Lordship, the decree ends at page 45.
Yes.
Page 45, which is internal page 12. It says that in view of the discussion made, it was detailed. It's a detailed order.
Yes.
And the title suit was decreed in my favor. Thereafter, the petitioners herein, they came through a civil appeal, which was civil appeal number 1.
Where's that?
Of 20. They have not annexed, Your Lordship.
You have not annexed it also?
No.
And the second appeal also is still pending.
You know about that? No.
Yeah, I know, Your Lordship. But
Then?
here, my application before the respondent is not for a declaration of suit or ownership, Your Lordship.
Over and above now the declaration is there, showing that the line of succession is clear, and so they are entitled to a declaration that they are a rightful owner of the land. Correct?
Yes.
Now you're saying that now to sabotage that, you've gone under Section 8 of the MLTR to say that there's no power to transfer being between non-tribals. Correct?
Yes, Your Lordship.
So you
Because-
draw and
because-
make yeah?
Because her claim is based on this unregistered sale deed, Your Lordship, which is a complete violation under section.
But that's been taken up the suit. That issue.
No, Your Lordship, that issue was never raised, Your Lordship, before the lower court.
It was raised, Your
No,
Lordship,
Your Lordship.
page number 35 of the decree, of the judgment there, para 3. It was categorically stated by the respondent number 3 herein. Page 35 of the judgment, para 3. My Lordship has it.
Yes.
Plaintiff's case in brief. May I read it, Your Lordship?
Yes.
Para 3, Your Lordship, that the plaintiff originally came into possession of the aforesaid plot of land in the year 1974 from the Korfa tenant. Now, he is not the real owner. Korfa tenant, one Ali Muddin Sheikh, who is the father of the petitioner number 1 herein. And the plaintiff purchased the possessory rights of the Korfa tenant on 30th 10 1974, and to that a kacha sale hand note was executed by late Alamuddin Sheikh, as the transfer of the rights of Korfa tenants was applicable under Jotedas land and was in force in respect of the Jotedas land.
Not been what issues are taken up.
No, with regard with this section 3, Your Lordship, because the illegal transfer, Your Lordship.
No, that because it's prior the prohibition, if you know, the law came in 78. Okay, prior to 78, to transact for sale of
No,
land.
the regulation
Now,
is
if
come
the
as-
rights of the respondent.
I think
were there since 74.
No,
that means that there's no question of land transfer, MLTR coming in. Okay, number one. Number two, now, if you're trying to upstage the entire proceedings for civil court by the applicant section 8, but the DC should dismiss it, then at least.
Yes,
Mr. Harmi.
and Your Lordship, here.
Lordship, because the suit was filed and thereafter
Well,
the
then
appeal.
DC should say the suit's there, dismiss it. We'll dismiss it now.
And thereafter pending, so
Because
appeal is pending.
We'll dismiss your case.
Your Lordship,
Yes.
because this treaty was executed in 74, Your Lordship, and this regulation came on 72, Your Lordship. That's why.
No. See, there were amendments. 78 was a complete ban on transfer. Okay, before that, you could transfer with the permission of competent authority. So it came 71, 72, 74 amendments, 78 was the complete ban. You read the Act, and Section 4 gives exemptions where you can transfer land. We take down, yes, this writ petition has been filed. Bring that with this petition has been filed with a prayer. To direct the one number 2 dispose of the petition's application filed under, where is that? Section 8.
Section 8.
Of the Section 8 of the Meghalaya Land Transfer of Land bracket Regulation Act 1971. Stop. The reason for it is submitted that the petitioner has been constrained to oppose this court in view of the fact that since the filing the said application, which was received by the office 1 number 2, nothing has proceeded after that. The next paragraph, Mr. D. Nyota, alleged counsel for the petitioner, praised that the writ petition can be disposed of only with direction that the matter be taken up for disposal by the matter be taken up by the respondent number 2, and orders passed thereon. Next paragraph, Mr. P. Paske, however, appearing for the respondent number 2.
No, number 3.
Respondent number 3.
Number 3 has, however, submitted that the application before the respondent 2 would not be maintainable in view of the fact that the subject matter in issue, that is a plot of land, is already pending before a civil court, and that in fact a civil court, and that the trial court on when is the pronounced on
Lordship 26/4/2019
had decreed the suit in favor of the respondent number 3, who was the defendant, or who was the petitioner therein, and the respondent, one of the defendants. If it is further submitted, attention of the court been drawn to the affidavit also filed by respondent number 3, wherein the judgment decree has been enclosed. Further submitted by Pasque that the issue which has been raised now by the petitioner was already subject matter of the suit itself, and that the appeal against the judgment decree is pending. They have submits that at this stage no orders are called for, the representation be dismissed. This court, having heard the counsel of the parties, and on perusal of the materials as placed, Tom, next last paragraph, the last paragraph of this court. It is noted that the suit had been decreed in 2019, whereas the application by the writ petitioner under Section 8 of the Mega Transfer of Land Regulation Act had been filed only in July 2022, after said suit had been decreed. It is not understood as to why the writ petitioner, who was the defendant therein, did not raise the matter, or it's not understood as to how the petitioner at this stage seeks to raise the matter which was already subject matter issue before in the civil proceedings. In this view, the matter, there's nothing for consideration in the incident writ application, and the same is dismissed. Yes.
All right.
Deeply obliged, Your Lordship.
43.
Can't abuse the process. Yes.
My Lord, I pray that, my Lord, I have to file an additional affidavit.
Why 14 days now? It's gone long time ago.
No, my Lord, certain important facts has come, my Lord.
One important facts. Now you want to know who gave imprisonment to you.
My Lord.
And now you found out that who gave imprisonment is the commander of 13 NDRF.
My Lord.
Right, then?
There is a notification, my Lord. 13 NDRF cannot punish, my Lord.
Well, the punishment, he already served a rigorous
My
imprisonment.
Lord, he has been served.
Can we take that away?
That's what the bone of contention of challenge, my Lord. That was an illegal punishment awarded to me. There is a
But you
notification.
already served your sentence.
My Lord,
Then?
my Lord, serve the sentence.
You want compensation?
Definitely, my Lord. It's an illegal
You want to file additional,
additional affidavit, my Lord.
Yes, it's just from the matter. Yes, Mr. Arja submits that he has instructions that that the punishment which was meted out to the petitioner was unauthorized.
No.
As Commandant 13 NDRF bracket Armstrong has no authority to do so.
To do so.
So he prays you have to bring an additional affidavit to bring this fact on record.
No.
Praise allowed this after 2 weeks, yes.
Hello.
45.
This is a Home Guards matter, Lordship. One matter my Lord has already disposed of with regard to the revision of pay, Lordship. This is a matter where I have been disengaged, not by the, not discharged by the appointing authority. It was disengaged by the requisition authority, Lordship. There is no order from the appointing authority saying that in view of the disengagement that your service has been discharged, because the law which govern the appointment and discharge of the Home Guards, Lordship specifically provides.
You challenge the early order.
My Lord.
You challenge the early order. Where's the early order?
I have challenged that order of disengagement, Lordship.
No.
That one would.
Writ appeal? No appeal with early order. Where's that?
No, they have not. That is with regard to the revision of pay, Lordship. That has already been settled, Lordship.
Regard to revision of pay, Your Lordship, that has not been challenged.
My Lord, this is different, Lordship.
Where is the order? You said similar. Just now you said similar, now you say
Your
different.
Lordship, similar in the sense that it's the same
Similar and
petitioner.
different at the same time.
My Lord, so far as the revision of pay is concerned, Lordship, that matters have already been disposed of, Lordship. My Lord have passed the order, Lordship. That Gulab Sena case, Lordship, pertaining to that revision of pay, Lordship. Here, Lordship, whatever, when the matter was pending for revision of pay matter, Lordship, then I have been disengaged by the requisition authority, Lordship. The order of disengagement was not communicated to me. Then I have make a submission before this honorable court that I was not paid the salary. Then my Lord has passed some order. Then I communicated the order. After communicating the order, they have simply said that we cannot pay the salary, Lordship. After that, Lordship, after few months, they have communicated the order of disengagement. But there is no order of discharge from the appointing authority, Lordship.
Which is the Home Guard.
Yes, Home Guards, Lordship. Because, Lordship.
Yes.
Yeah.
Yes, where is that?
Are you appointment?
Show the early order. It's not here. You don't have it with you, Mr. Sheikh.
Lordship, that order is.
The least you can do is bring the early order, which is similar or different.
This is, Lordship, that matter is with regard to only revision of pay, Lordship. My Lord has directed.
Does it have any bearing on this matter?
No, Lordship.
No.
No, Lordship.
Okay.
No, Lordship.
Yes.
Lordship will kindly come to page 13, Lordship. That is my appointment order, Lordship.
Yes.
The type copy is the next page, Lordship, page 13A. May I read, Lordship?
Yes.
In the interest of the public service, the following trained Home Guards volunteers are temporarily appointed as guardsmen with effect from so-and-so, 1986, Lordship, in the pay scale of so-and-so per month, plus other allowances as admissible under the Meghalaya Service Pension Revision of Pay Rules. Here I am, Lordship, the petitioner, serial number 2, 3, and 5, Lordship.
Okay.
Now, after that, Lordship, I was receiving the benefit of pay revision, Lordship. Then, Lordship, all of a sudden, the fifth pay revision, benefit of fifth pay revision was denied. Then I approached to this honorable court and filed a writ petition number 37 up to 2022, Lordship. Then, during the pendency of that writ petition, Lordship, now, Lordship, they have stopped my salary, Lordship. That is the requisition authority, that is the PSC, Lordship. Now, this fact I have brought it to the notice of this honorable court, Lordship, and this honorable court, Lordship, by page 34, Lordship,
Yes.
Lordship. That is the order passed in writ petition number 37, Lordship.
Yes.
The subject matter to issue in the present case is with regard to the non-grant of revised scale of pay as per the revision of pay rules 2017 to the petitioners who are stated to be the Home Guards personnel. Mr. So-and-so learned counsel for the petitioner submits that while the matter is pending before this honorable court, the pay of the petitioner has been stopped since January 2023 for reasons unknown. Mr. S. Abraham Learned GA for the respondent submits that though instructions have been received, he is not aware as to whether the petitioner's pay have been stopped. He is directed to obtain further instruction. It is further noted that the pendency of this writ petition shall not stand in the way of the petitioners being given their salaries provisional otherwise, Lordship. After that, Lordship, I have next page, I have communicated this order, Lordship. Then after communicating that order, Lordship, then they have issued letter, that is page 37, Lordship.
Yes.
That is the letter issued by the Home Guards. This is just a communication letter issued to the petitioner, Lordship.
Yes.
The content of the letter, with reference to the subject cited above, I am to inform you that your engagement for duty as Home Guards, volunteers with Rural Water Supply Division, PSC Joy, has been discontinued by the Office of the Chief Engineer, PSC, Meghalaya, Shillong, by letter number so-and-so, and the same has been communicated to you on 19/12/2022 when you visited my chamber seeking for clarification on the matter. Yes. The letter from the Chief Engineer was read and also physically shown and explained to you in the language you understood. Secondly, since your service has been discontinued since the end of December 2023, and you have not been engaged with any duties with PSC from the month of January 2023 onwards, the salary can no longer be paid, Lordship. My Lord, prior to that, Lordship, in the month of April, Lordship, I put up an application seeking for release of my salary, Lordship. And what is the response, Lordship, to that application, Lordship? My application is at page 31, Lordship. Annexure 5, 31. Yes. This letter was written to the Home Guards, Lordship. With reference to the subject cited above, we the undersigned have the honor to state that we have not received our salary for the month of January 2023 till now. That, sir, we are facing financial hardship, complications, and this sustained our family without the amount which we get from our salary. Therefore, we the undersigned fervently request you to kindly release our pending salary as soon as possible, and for which act of your generosity we shall remain ever grateful to you and thus oblige. And what is the response to it, Lordship? Page 33, Lordship. Page 33, this is also issued from the PSC, Lordship. This was made in reference to my application, Lordship. Although I have written the letter to the commandant, but that was in reference to my application, Lordship. Release of pending salary, letter number so-and-so. With reference to the subject and the letter mentioned above, this is to inform you that the salary from the month of January 2023 onwards cannot be paid anymore. This is for your information. Now, they are saying that since I have been disengaged from December 2022 by the PSC department, in the letter, they did not cite the reasons why my salary is stopped. They simply say that we cannot pay the salary. Why? Nowhere mentioned, Lordship. Now, Lordship, this is a letter of disengagement issued by the requisition authority, Lordship. There is no any letter from my appointing authority saying that since your service has been disengaged by the requisition authority, that your service has been discharged or you have been discharged from service. So I am still the employee of the Home Guards, Lordship, because I was appointed appointed by the Home Guards, and I was sent to the PSC department for my duties, Lordship. Now they have disengaged me, not the Home Guards, Lordship. Now what the law says, Lordship?
Yes.
Now, Lord, Section 2, this is the applicability of the Act, Lordship, the Assam Home Guards Act 1947. On the top, Lordship, adopted, Lordship. Now, since my Lord may kindly come to next page, Lordship, appointment and discharge, Lordship. Section 6, Lordship.
Yes.
Subject to the provision of this Act and to the rules made thereunder, any person willing to serve as a home guards and possessing such qualification as may prescribe may be appointed as home guards. The appointment of home guards shall be made in such manner and by such authority as may be prescribed. Every officer and every man of home guards shall receive on his appointment a certificate in the form annexed to this Act under the seal of the Commandant General in the case of officers and the Commandant in the case of men, by virtue of which a person holding such certificate shall be vested with the power and privilege of a home guards. Such certificate shall cease to have effect wherever the person named in it ceases to be the home guards, and on his so ceasing shall within 10 days be surrendered by him to the Commandant General if he is an officer, and to the Commandant if in all other cases. Now this is the policy of appointment, Lordship. Now next is duties. Now discharge policy, Lordship. Section 8, Lordship, below down.
Yes.
Now every man, officer and man of the home guard shall be entitled to receive his discharge from the home guards on the expiration of his period of service in the reserve. But any such person may, before he becomes so entitled, be discharged by such authority and subject to such condition as may be prescribed. The prescribed authority may, subject to such condition as may prescribe, dismiss any officer or man from the home guards. Next page, Lordship. Powers and function of the home guards. Subject to the provision of this Act or the rules made here under a home guards when called under Section 10 shall have the same power, privilege and protection as an officer of police appointed under any enactment for the time being in force. My Lord, my powers and functions, if I commit any wrong, then I will be prosecuted under the relevant rules, Lordship. Now, as per the discharge policy, Lordship, that after the period of my service, Lordship, it is the duty of the Commandant to issue discharge certificate.
But I think we saw somewhere that if the requiring agency doesn't require any more, you're considered to be discharged.
That is, Lordship, this is the order of disengagement. That is the internal arrangement between the appointing authority and the requisition authority.
Page 36 of
yes,
the
Lordship.
writ petition, Your Lordship.
That is the order of disengagement by the PSC, Lordship. That order I have challenged. 36, Lordship. Kindly below what the PSC has written. The last line, Lordship.
Yes.
Therefore, in this matter, it is to inform that the service of the concerned home guards personnel may kindly be discontinued. Have they followed this?
Yes.
They have cited point 9. Point 9 is the internal arrangement between the appointing authority and the requisiting authority. This is the internal communication.
The case is that, notwithstanding anything else, if you are to be discontinued in service, there should come a formal order from the Commandant.
True, Lordship.
That's all.
True, Lordship.
And so, for the time that you've not been discontinued, entitled some salary.
Yes, Lordship.
That's what you want.
That is my case.
Who will pay you?
This is the Commandant, Lordship. Home guards.
Who will pay from his pocket?
No, from the they have to pay, because the order also says that please kindly issue a letter saying that your service has been discontinued, and unless my service has been discontinued or terminated or any issues,
yes, Mr.
then
May it please your Lordship. Lordship, kindly come to page 13A. That is the type copy of the order of appointment. If Lordship kindly come below. Lordship, kindly see the appointment is purely temporary and specifically
page 13 small a, Your Lordship. That is the type copy of the order of appointment of 1986.
No, that's what he's saying. The service above
Lordship, kindly see the services. The services of the above GM may be terminated at any time on 1 month's advance notice without assigning any result thereof. Your Lordship, my humble and respectful submission, Your Lordship, keeping a one month's advance notice, Your Lordship, is not mandatory.
Where's the order of discontinuance?
Lordship, the order of discontinuance, Your Lordship, kindly see at page 36. This is the letter written by the requisitioning agency, Your Lordship, to the Commandant of Home Guard, Your Lordship. This is his letter, Your Lordship. And accordingly, Your Lordship, the District Home Guard Commandant at page 37, Your Lordship,
yes,
has issued that letter. Lordship, disengaging.
What he's saying is that, okay, fine. By your actions, you say discriminate. But where's the black and white letter?
Lordship, this one. This is the at 37, Your Lordship. At page 37, that is the letter. That is the order issued by the District Home Guard Commandant, Jawa, Your Lordship, to the writ petitioners. So this will suffice. Lordship, yes. Lordship, yes, will suffice.
So where's the order passed in December then?
That is 36, Lordship.
36, Your Lordship.
Did you pay them 4 months salary till May?
No, Your Lordship. Lordship, can you see? They have been discontinued from December 22, and Your Lordship, they have not done for the whole year of 23. Your Lordship, they have not done anything. Your Lordship.
Now you've not done this formally. Now you pay them for January, February, March, April.
Lordship, in my humble and respectful submission, Your Lordship, it is not informing.
See,
1 month notice, Your Lordship, is.
It is very simple. It's just that if you discontinue the services, it should be communicated to them. Now, the only communication, first time they say that is when they received the letter, 19 June 23.
Lordship, this is 23, Your Lordship. June 23.
19 June 23.
They have been disengaged, Your Lordship. From December 22.
The first December 22 is letter of the PHA. Correct?
Your Lordship, yes.
Now it's saying that, therefore, in this matter, it is to inform services may kindly be discontinued.
Lordship, yes.
Request for discontinuance of the services. Correct? Now you're the authority to place them there. Right? That is the only gap. Is not saying that she does not say, or he or she, whatever it is.
Kindly see, Your Lordship.
The services are discontinued.
Kindly see, Your Lordship. And at page 37, Your Lordship, secondly, since your service had been discontinued since the end of December,
and you from the Home Guard?
And you have not been engaged with any duties from the month of January onward, the cell cannot be page. That means they are throughout 2023, they are not doing any work, Your Lordship. So where is the question of paying them salary? Salary cannot be paid. If they don't do the work, it cannot be paid, Your Lordship.
You can't take the argument. The thing is that whatever now this 1st December 2022 written to you, that written to the Home Guards, that therefore in this matter is to inform you that the service concerned Home Guards personnel may kindly be discontinued. So this chief engineer is saying, please discontinue the services of the PHE or of these Home Guards. Now they don't know anything; they're just hanging around. The 19 June, when the office is given the order that
yes, Lordship,
my lord,
and the letter,
authority.
I'll just quickly respond, Lordship. That too also under what circumstances when I place the court order saying that pendency of the writ petition, in that circumstances, Lordship, they had communicated. Although they have made some oral, that is I was not aware, Lordship. They are the appointing authority. They have the power to discharge.
They are not doing any work, Your Lordship. So where is the question of paying a salary, Your Lordship?
How many government officers do work?
That, Your Lordship, is.
How many people we go to any office now? Count the attendance. Who's there?
Lordship, the letter of the
use the same yardstick. Then they're still in service. They don't do work. Don't pay them.
Lordship, the letter of the district home guard commandant Lordship, is very clear. They are not, they were not doing any work, Your Lordship.
Very clear. They have communicated.
They were not doing any work.
On 19 June only that since your service conditions in December.
Lordship, kindly see, Your Lordship. Lordship, if we are to pay for the work for which they have not done, Your Lordship, it's a public money, Your Lordship. It's a public money, Your Lordship.
I want to see that there was a request letter from PHE on 1st December. Please just continue services.
Lordship,
Nothing
yes.
was done. Then one fine day, 19 June, you say your service conditions.
In fact, Your Lordship, the letter is very clear that from December, they have discontinued, Your Lordship.
Did they know about it before?
They have been discontinued. They must have known, Your Lordship, because they are not going for work anymore, Your Lordship. They are not doing any work anymore, Your Lordship.
See, Mr. Shula, you can't take the argument. Simple case is this. There's a request for discontinuance. You didn't do anything. Only 19 June, you told them, okay, discuss in December. So?
Lordship, as I have submitted, Your Lordship, they have been their service.
Let's see your affidavit. What do you say? You can counter that. Then give them some consolidated pay.
Well, I am retiring next year, February and March, Lordship.
So you're not service anymore now. Even you consider you
True, Lordship. True. I have very short period, Lordship. My Lord, this is affidavit by on behalf of the. In my writ petition, I have enclosed the counter of writ petition 37 also, Lordship. Here, Lordship.
Lordship, the affidavit is neither here nor there, Your Lordship.
Then who drafted the affidavit?
Lordship, by a government advocate, Your Lordship.
Actually? Oh, no wonder. Yes, not saying anything about. How did talk about realization if a commission is only against this judge?
The affidavit relates to the earlier writ petition, Your Lordship. It appears.
Yes.
In the page 8 of the affidavit also, Lordship.
Compendium.
Compendium, yes, Lordship. 1 subclause 10. Home Guards enrollment policy, Lordship. In the next page, Lordship, says it is observed that some states, by retaining those members over long period, erosion in the voluntary character of the organization is taking place. Now they cannot take that issue also. I have been serving for more than 35 years. Now what my learned senior is saying that I am not in work, Lordship, they can take action against me. But simply issuing a letter saying that no, this can be treated as discharge, no, Lordship. My submission as on today, I am still the employee of the Home Guards, Lordship.
On today, no.
No.
After 19 June, no.
No, Lordship, that my Lord, as if they issue the discharge certificate as on today, Lordship, until I have been discharged, Lordship, from the office of the Commandant, Lordship, Home Guards.
See, you know why, Mr. Shulai?
Lordship.
Because it is a question not working. They have not received any order of discontinuance. That's why they came to court with this petition, or the earlier petition, saying that we have not been paid. Please pay us. That's all. And once this petition was brought on record, they should have taken steps.
Yes, Lordship.
Why wait for them to, to give the order, like, penancy of the petition shall not bar the respondents from consent?
They could have immediately issued discharge certificate.
Because the largest part of the
Yes.
officers only who are. The thing is that you have to face it. Now, I think there's a request, there's a valid request for discontinuance from 1st December. That means that PHE was very diligent. They said 1st December, they give letter to you that from up to December, we don't need them anymore.
Lordship, kindly see, Your Lordship, the money is not paid by the Home Guard, it's paid by the
We know that.
department.
Now Home Guard, now they have the responsibility.
And Lordship, the fact remains, Your Lordship, that they were no longer in engagement, Your Lordship, since December 22, Your Lordship, and for the whole year.
22, 30 or 37, right?
Lordship, yes, and for the whole year, Your Lordship, as seen from this letter, Your Lordship, they were not doing anything, Your Lordship.
Not whole year. You have to
no,
pay
Your
them
Lordship,
from
I kindly
January,
see,
February,
and you have not been
March,
with any
April,
duty
4 months.
from the month
How
of
much
January,
do you
Your Lordship.
My Lord, my prayer is as on today till the issuance of the discharge certificate, Lordship. They have to issue the
January
discharge
23
certificate, Lordship.
onwards, Your Lordship.
We'll not consider that.
My Lord.
How much is your daily, was your monthly pay?
Monthly, above 30,000, Lordship.
1-3?
Yeah, 30,000. Yes,
30,000.
3. Because they are getting the regular pay scale, Lordship, at par with the home guards under the state government, Lordship. My Lord, what my contention is like.
They were not in service, Your Lordship.
But they have to issue, today they can issue order saying that discharge.
Balance equities.
My Lord,
Punish them, some more punishment for them and for you also. You cannot just expect to take the cake, take the baker and the bakery also.
And my Lord will kindly appreciate one thing, Lordship. Under what circumstances I have been discontinued, Lordship, because I have filed the case, Lordship. My Lord also kindly appreciate that aspect also, Lordship. All throughout almost 35 years, Lordship, I have been serving, Lordship. There was no hindrance, Lordship. Moment I file, moment I start agitating my rightful entitlement, Lordship, I have been disengaged. Abruptly, Lordship, without any notice, Lordship.
Yes.
At least being a model officer, Lordship, model employer, they should follow the at least the basic principles of law, Lordship. We have to, my Lord, kindly have to appreciate the modus operandi of the respondent, Lordship. Under what circumstances I have been decided.
What you, Mr. Sheikh, we understand the case. So we think how to balance equities. Now, where is that compendium where they say the services of the Home Guard be placed at the disposal of the requisitioning authority? And whether that can amount to...
My Lord, they have enclosed that that agreement, Lordship, in the...
What was the agreement? In the affidavit?
Yes, in the affidavit. That is at page 12, Lordship. Page 12. Para 9, that is the terms and conditions set out. That is the between the appointing authority and the requisition authority, Lordship.
That's what they did. Within 90 days they disengaged them. See, as per 9, by 30 days fine notice was given to the department.
Yes. And that is why in the letter dated 1st December 2022, Lordship, they have specifically mentioned. So far as the notice period between the requisition authority and the appointing authority, they have complied, Lordship, that requisition authority.
Lordship, kindly come to page... the page E, Lordship.
No, now for the period.
Lordship, kindly come to page 12, at clause 3.
Yes.
The engagement of Home Guard, Lordship, at clause 3 of page 12, Your Lordship. Yes. The engagement of Home Guard volunteers shall be complete at the cost of the requisitioning agencies, and the duty allowance shall not be less than the duty allowance prescribed by the state government or the government of India in the case of...
You can't saddle PHE responsibility because they already given a notice as per 9, as a condition.
Lordship,
number
then
9.
the Home Guard...
Home Guard is a person, they should have immediately or received that first letter, given them discharge, finish. They didn't do that. So you take nominal pay, 10,000 per month for 4 months.
My lord, that is to be too. At least, lordship. In fact, till June, lordship.
See, Home Guards are totally a voluntary service. It's the nature of a Home Guard is a volunteer.
Volunteer.
My lord,
it's not a question of being bound. You know, it's not a question of master servant also. It's a question of a volunteer.
My lord is absolutely right, lordship.
Yeah.
If I was engaged for a period of 3 months or 1 year like this, then there is a break. After that, again deployment. Then their service can be said that their service is voluntary in nature. Once they have continuously service for a period of 35 years.
That has no meaning.
No, lordship.
You take instructions that you pay them some amount of 10,000 per month.
How much, Your Lordship?
10,000 per month.
10,000. From the Home
Take
Guard?
it or leave it. From the Home Guard.
Lordship, yes.
You have to pay, otherwise, because they have you explain to them that
Lordship, yes.
This matter further hearing on so and so. Stop. It is noted herein that on it is noted by this court that apart from the letter dated 19 June 2023, there is no communication or formal discharge of the writ petitioners, even though notice for discontinuance of the service by the requesting department had been sent as far back as on 1st December 2022. Stop. As there was no formal disengagement for 4-month period, the AG to take instructions with regard to compensatory allowance to be paid to petitioners for the said 4 months. Yes. That's all.
Will come on 29, Your Lordship.
29, whatever.
This will be, if it is June, lordship, then 6 month, lordship, because January,
Why
February,
6 months?
March, April.
January, February, March, April, May.
5 months then.
Why 5 months? 5 months. 5 months, yes.
5 months. If as per my lordship.
Take home 50,000 each.
Apply.
Have a party, yes.
47.
Highly honored.
May it please your Lordship.
Yes.
Lordship, I am appearing for the petitioner in this matter. I was informed yesterday by Ms. Gurung that the Learned Senior Counsel will not be able to take up the matter today.
Where's Mr. Dr. Moses? Didn't come to court
Your
today?
Lordship, he's on legs before division bench, Your Lordship.
When listed then? When?
Your Lordship, 2 weeks.
2 weeks. 2 weeks. Yes,
Lordship.
as the arguing counsel senior for on behalf of the respondent number.
Respondent.
1, 2, 3, Your Lordship.
Is that available? This is a matter after 2 weeks, yes.
Obliged.
48.
May I please your Lordship? Your Lordship, I'm appearing for respondent 1 and Lordship, I'm praying for 2 weeks time. Actually, I missed out mentioning this morning, Your Lordship. Something in the consent of the petitioner also.
Have you left the premises?
No, Your Lordship.
I'm
Still there?
Yes, Your Lordship.
They'll come after 2 weeks, Your Lordship. Hearing.
You're avoiding the matter.
No, Your Lordship.
They are taking advantage, Your Lordship, because
Lordship. Actually, what happened, Lordship, my mistake, I was not aware. I had gone through cost list, but I did not see the matter was listed today, Your Lordship.
Okay, on the prayer of MSL point of the person's faculty, this is a matter of 2 weeks.
Highly obliged, Your Lordship.
Madam.